Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Andy Warhol Foundation for Visual Arts Incorporated v. Goldsmith. In this case, the court considered this issue: what is the proper test for whether a work is transformative under the first factor of the Copyright Act's fair use doctrine? The case was decided on May 18, 2023. The Supreme Court held that the purpose and character of the Andy Warhol Foundation, AWF's particular commercial use of Lynn Goldsmith's photograph of the musician Prince does not favor AWF's fair use defense to copyright infringement. Justice Sonia Sotomayor authored the 7-2 majority opinion of the court. The fair use defense to copyright infringement promotes creativity by recognizing that some secondary works make unauthorized use of original works, but serve a different purpose, add new expression, or convey new ideas. Andy Warhol's Orange Prince, one of the Prince series that was derived from the photograph by Lynn Goldsmith, appeared on the cover of a Vanity Fair magazine commemorating the late musician for a fee of $10,000, all of which to AWF and of which Goldsmith received none. In contrast, Goldsmith's photographs were licensed and used on several other magazine covers commemorating Prince. AWF's use of Orange Prince on the cover of Vanity Fair served essentially the same commercial purpose as Goldsmith's original. Thus, the first fair use factor, the purpose and character of use, including whether the use is for commercial or non-profit purpose, weighs against the conclusion that AWF's use of Goldsmith's photograph for the specific purpose of a magazine cover commemorating Prince was fair. Justice Neil Gorsuch authored a concurring opinion, in which Justice Ketanji Brown Jackson joined, emphasizing the narrowness of the majority's opinion and its appropriate focus on the specific use challenged. Justice Elena Kagan authored a dissenting opinion, in which Chief Justice John Roberts joined, criticizing the majority of stifling creativity and disregarding the reality that creativity relies upon the borrowing of works that came before. Note, the court's opinion here included pictures and paintings. Those images are not captured in this recording. I encourage you to find the opinion online and review the images referenced here. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Sotomayor delivered the opinion of the court. This copyright case involves not one, but two artists. The first, Andy Warhol, is well known. His images of products like Campbell's soup cans and of celebrities like Marilyn Monroe appear in museums around the world. Warhol's contribution to contemporary art is undeniable. The second, Lynn Goldsmith, is less well known, but she too was a trailblazer. Goldsmith began a career in rock and roll photography when there were few women in the genre. Her award-winning concert and portrait images, however, shot to the top. Goldsmith's work appeared in Life, Time, Rolling Stone, and People magazines, not to mention the National Portrait Gallery and the Museum of Modern Art. She captured some of the 20th century's greatest rock stars: Bob Dylan, Mick Jagger, Patti Smith, Bruce Springsteen, and, as relevant here, Prince. In 1984, Vanity Fair sought to license one of Goldsmith's Prince photographs for use as an artist reference. The magazine wanted the photograph to help illustrate a story about the musician. Goldsmith agreed, on the condition that the use of her photo be for one time only. The artist Vanity Fair hired was Andy Warhol. Warhol made a silkscreen using Goldsmith's photo, and Vanity Fair published the resulting image alongside an article about Prince. The magazine credited Goldsmith for the source photograph, and it paid her $400. Warhol, however, did not stop there. From Goldsmith's photograph, he derived 15 additional works. Later, the Andy Warhol Foundation for the Visual Arts Incorporated, AWF, licensed one of those works to Condé Nast, again for the purpose of illustrating a magazine story about Prince. AWF came away with $10,000. Goldsmith received nothing. When Goldsmith informed AWF that she believed its use of her photograph infringed her copyright, AWF sued her. The district court granted summary judgment for AWF on its assertion of fair use, but the Court of Appeals for the Second Circuit reversed. In this court, the sole question presented is whether the first fair use factor, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes, weighs in favor of AWF's recent commercial licensing to Condé Nast. On that narrow issue, and limited to the challenged use, the court agrees with the Second Circuit. The first factor favors Goldsmith, not AWF. Lynn Goldsmith is a professional photographer. Her specialty is concert and portrait photography of musicians. At age 16, Goldsmith got one of her first shots, an image of the Beatles' trendy boots before the band performed live on The Ed Sullivan Show. Within 10 years, Goldsmith had photographed everyone from Led Zeppelin to James Brown, the latter in concert in Kinshasa, no less. At that time, Goldsmith had few female peers, but she was a self-starter. She quickly became a leading rock photographer in an era when women on the scene were largely dismissed as groupies. In 1981, Goldsmith convinced Newsweek magazine to hire her to photograph Prince Rogers Nelson, then an up-and-coming and hot young musician. Newsweek agreed, and Goldsmith took photos of Prince in concert at the Palladium in New York City, and in her studio on West 36th Street. Newsweek ran one of the concert photos, together with an article titled The Naughty Prince of Rock. Goldsmith retained the other photos. She holds copyright in all of them. One of Goldsmith's studio photographs, a black-and-white portrait of Prince, is the original copyrighted work at issue in this case. In 1984, Goldsmith, through her agency, licensed that photograph to Vanity Fair to serve as an artist reference for an illustration in the magazine. The terms of the license were that the illustration was to be published in Vanity Fair November 1984 issue. It can appear one time full page and one time under 1/4 page. No other usage right granted. Goldsmith was to receive $400 and a source credit. To make the illustration, Vanity Fair hired pop artist Andy Warhol. Warhol was already a major figure in American art, known among other things for his silkscreen portraits of celebrities. From Goldsmith's photograph, Warhol created a silkscreen portrait of Prince, which appeared alongside an article about Prince in the November 1984 issue of Vanity Fair. The article, titled Purple Fame, is primarily about the sexual style of the new celebrity and his music. Goldsmith received her $400 fee, and Vanity Fair credited her for the source photograph. Warhol received an unspecified amount. In addition to the single illustration authorized by the Vanity Fair license, Warhol created 15 other works based on Goldsmith's photograph, 13 silkscreen prints and 2 pencil drawings. The works are collectively referred to as the Prince series. Goldsmith did not know about the Prince series until 2016, when she saw the image of an orange silkscreen portrait of Prince, Orange Prince, on the cover of a magazine published by Vanity Fair's parent company, Condé Nast. By that time, Warhol had died, and the Prince series had passed to the Andy Warhol Foundation for the Visual Arts Incorporated. AWF no longer possesses the works, but it asserts copyright in them. It has licensed images of the works for commercial and editorial uses. In particular, after Prince died in 2016, Condé Nast contacted AWF about the possibility of reusing the 1984 Vanity Fair image for a special edition magazine that would commemorate Prince. Once AWF informed Condé Nast about the other Prince series images, however, Condé Nast obtained a license to publish Orange Prince instead. The magazine, titled The Genius of Prince, is a tribute to Prince Rogers Nelson, 1958 to 2016. It is devoted to Prince. Condé Nast paid AWF $10,000 for the license. Goldsmith received neither a fee nor a source credit. Remember that Goldsmith too had licensed her Prince images to magazines such as Newsweek, to accompany a story about the musician, and Vanity Fair to serve as an artist reference. But that was not all. Between 1981 and 2016, Goldsmith's photos of Prince appeared on or between the covers of People, Reader's Digest, Guitar World, and musician magazines. People magazine, in fact, paid Goldsmith $1,000 to use one of her copyrighted photographs in a special collector's edition, celebrating Prince, 1958 to 2016, just after Prince died. People's tribute, like Condé Nast's, honors the life and music of Prince. Other magazines, including Rolling Stone and Time, also released special editions. All of them depicted Prince on the cover. All of them used a copyrighted photograph in service of that object. And all of them, except Condé Nast, credited the photographer. When Goldsmith saw Orange Prince on the cover of Condé Nast's special edition magazine, she recognized her work. It's the photograph, she later testified. Orange Prince crops, flattens, traces, and colors the photo but otherwise does not alter it. Goldsmith notified AWF of her belief that it had infringed her copyright. AWF then sued Goldsmith and her agency for a declaratory judgment of non-infringement or, in the alternative, fair use. Goldsmith counterclaimed for infringement. The district court granted summary judgment for AWF. The court considered the 4 fair use factors enumerated in 17 U.S.C. Section 107, and held that the Prince series works made fair use of Goldsmith's photograph. As to the first factor, the works were transformative because, looking at them and the photograph side by side, they have a different character, give Goldsmith's photograph a new expression, and employ new aesthetics with creative and communicative results distinct from Goldsmith's. In particular, the works can reasonably be perceived to have transformed Prince from a vulnerable, uncomfortable person to an iconic, larger-than-life figure, such that each Prince series work is immediately recognizable as a Warhol rather than as a photograph of Prince. Although the second factor, the nature of Goldsmith's copyrighted work, creative and unpublished, would ordinarily weigh in her favor, this factor was of limited importance because the Prince series works are transformative. The third factor, the amount and substantiality of the portion used in relation to the copyrighted work, favored AWF because, according to the district court, Warhol removed nearly all the photograph's protectable elements in creating the Prince series. Finally, the fourth factor likewise favored AWF, because the Prince series works are not market substitutes that have harmed or have the potential to harm Goldsmith. The Court of Appeals for the Second Circuit reversed and remanded. It held that all four fair use factors favored Goldsmith. On the first factor, the purpose and character of the use, Section 107(1), the Court of Appeals rejected the notion that any secondary work that adds a new aesthetic or new expression to its source material is necessarily transformative. The question was, instead, whether the secondary work's use of its source material is in service of a fundamentally different and new artistic purpose and character. Such transformative purpose and character must, at bare minimum, comprise something more than the imposition of another artist's style on the primary work. Here, however, the overarching purpose and function of the two works at issue is identical, not merely in the broad sense that they are created as works of visual art, but also in the narrow but essential sense that they are portraits of the same person. The Court of Appeals also rejected the district court's logic that each Prince series work is transformative because it is immediately recognizable as a Warhol, which the Court of Appeals believed would create a celebrity plagiarist privilege. The fact that Martin Scorsese's recent film The Irishman is recognizably a Scorsese does not absolve him of the obligation to license the original book. On the other three factors, the Court of Appeals found that the creative and unpublished nature of Goldsmith's photograph favored her, that the amount and substantiality of the portion taken, here, the essence of the photograph, was not reasonable in relation to the purpose of the use, and that AWF's commercial licensing encroached on Goldsmith's protected market, to license her photograph to publications for editorial purposes, and to other artists to create derivative works. The court noted that there was no material dispute that both Goldsmith and AWF have sought to license, and indeed have successfully licensed, their respective depictions of Prince to popular print magazines to accompany articles about him. Finally, although the district court had not reached the issue, the Court of Appeals rejected AWF's argument that the Prince series works were not substantially similar to Goldsmith's photograph. Judge Jacobs concurred. He stressed that the Court of Appeals holding did not consider, let alone decide, whether the infringement here encumbers the original Prince series works. Instead, the only use at issue was the Foundation's commercial licensing of images of the Prince series. This court granted certiorari. AWF does not challenge the Court of Appeals holding that Goldsmith's photograph and the Prince series works are substantially similar. The question here is whether AWF can defend against a claim of copyright infringement, because it made fair use of Goldsmith's photograph. Although the Court of Appeals analyzed each fair use factor, the only question before this court is whether the court below correctly held that the first factor, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes, weighs in Goldsmith's favor. AWF contends that the Prince series works are transformative, and that the first factor therefore weighs in its favor, because the works convey a different meaning or message than the photograph. The Court of Appeals erred, according to AWF, by not considering that new expression. But the first fair use factor instead focuses on whether an allegedly infringing use has a further purpose or different character, which is a matter of degree, and the degree of difference must be weighed against other considerations like commercialism. Although new expression may be relevant to whether a copying use has a sufficiently distinct purpose or character, it is not, without more, dispositive of the first factor. Here, the specific use of Goldsmith's photograph alleged to infringe her copyright is AWF's licensing of Orange Prince to Condé Nast. As portraits of Prince used to depict Prince in magazine stories about Prince, the original photograph and AWF's copying use of it share substantially the same purpose. Moreover, the copying use is of a commercial nature, even though Orange Prince adds new expression to Goldsmith's photograph. As the district court found, this court agrees with the Court of Appeals that, in the context of the challenged use, the first fair use factor still favors Goldsmith. The Copyright Act encourages creativity by granting to the author of an original work a bundle of exclusive rights. That bundle includes the rights to reproduce the copyrighted work, to prepare derivative works, and, in the case of pictorial or graphic works, to display the copyrighted work publicly. The Act, however, reflects a balance of competing claims upon the public interest. Creative work is to be encouraged and rewarded, but private motivation must ultimately serve the cause of promoting broad public availability of literature, music, and the other arts. Copyright thus trades off the benefits of incentives to create against the costs of restrictions on copying. The Act, for example, limits the duration of copyright, as required by the Constitution, makes facts and ideas uncopyrightable, and limits the scope of copyright owners' exclusive rights. This balancing act between creativity and availability, including for use in new works, is reflected in one such limitation, the defense of fair use. In 1976, Congress codified the common law doctrine of fair use in Section 107, which provides, "The fair use of a copyrighted work, for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, is not an infringement of copyright. To determine whether a particular use is fair, the statute sets out 4 factors to be considered. 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. The fair use doctrine permits courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which that law is designed to foster. The Act's fair use provision, in turn, sets forth general principles, the application of which requires judicial balancing, depending upon relevant circumstances. Because those principles apply across a wide range of copyrightable material, from books to photographs to software, fair use is a flexible concept, and its application may well vary depending on context. For example, in applying the fair use provision, copyright's protection may be stronger where the copyrighted material serves an artistic rather than a utilitarian function. The first fair use factor is the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. This factor considers the reasons for and nature of the copier's use of an original work. The central question it asks is whether the new work merely supersedes the objects of the original creation, supplanting the original, or instead adds something new with a further purpose or different character. In that way, the first factor relates to the problem of substitution copyright's bête noire. The use of an original work to achieve a purpose that is the same as, or highly similar to, that of the original work, is more likely to substitute for or supplant the work. Consider the purposes listed in the preamble paragraph of Section 107: criticism, comment, news reporting, teaching, scholarship, or research. Although the examples given are illustrative and not limitative, they reflect the sorts of copying that courts and Congress most commonly have found to be fair uses, and so may guide the first factor inquiry. As the Court of Appeals observed, the examples are easily understood, as they contemplate the use of an original work to serve a manifestly different purpose from the work itself. Criticism of a work, for instance, ordinarily does not supersede the objects of or supplant the work. Rather, it uses the work to serve a distinct end. Not every instance will be clear-cut, however. Whether a use shares the purpose or character of an original work, or instead has a further purpose or different character, is a matter of degree. Most copying has some further purpose, in the sense that copying is socially useful ex post. Many secondary works add something new. That alone does not render such uses fair. Rather, the first factor, which is just one factor in a larger analysis, asks whether and to what extent the use at issue has a purpose or character different from the original. The larger the difference, the more likely the first factor weighs in favor of fair use. The smaller the difference, the less likely. A use that has a further purpose or different character is said to be transformative. As before, transformativeness is a matter of degree. That is important because the word transform, though not included in Section 107, appears elsewhere in the Copyright Act. The statute defines derivative works, which the copyright owner has the exclusive right to prepare, to include any other form in which a work may be recast, transformed, or adapted. In other words, the owner has a right to derivative transformations of her work. Such transformations may be substantial, like the adaptation of a book into a movie. To be sure, this right is subject to fair use. The two are not mutually exclusive, but an overbroad concept of transformative use, one that includes any further purpose or any different character, would narrow the copyright owner's exclusive right to create derivative works. To preserve that right, the degree of transformation required to make transformative use of an original must go beyond that required to qualify as a derivative. For example, this court in Campbell considered whether parody may be fair use. In holding that it may, the court explained that parody has an obvious claim to transformative value, because it can provide social benefit, by shedding light on an earlier work and, in the process, creating a new one. The use at issue in Campbell was 2 Live Crew Z copying of certain lyrics and musical elements from Roy Orbison's song, "Oh Pretty Woman," to create a rap derivative titled Pretty Woman. Without a doubt, 2 Live Crew transformed Orbison's song by adding new lyrics and musical elements, such that Pretty Woman had a new message and different aesthetic than Oh Pretty Woman. Indeed, the whole genre of music changed from rock ballad to rap. That was not enough for the first factor to weigh in favor of fair use, however. The court found it necessary to determine whether 2 Live Crew Z's transformation of Orbison's song rose to the level of parody, a distinct purpose of commenting on the original or criticizing it. Distinguishing between parody, which targets an author or work for humor or ridicule, and satire, which ridicules society but does not necessarily target an author or work, The court further explained that parody needs to mimic an original to make its point, and so has some claim to use the creation of its victims, or collective victims, imagination, whereas satire can stand on its own 2 feet and so requires justification for the very act of borrowing. More generally, when commentary has no critical bearing on the substance or style of the original composition, the claim to fairness in borrowing from another's work diminishes accordingly, if it does not vanish, and other factors, like the extent of its commerciality, loom larger. This discussion illustrates 2 important points. First, the fact that a use is commercial as opposed to non-profit is an additional element of the first factor. The commercial nature of the use is not dispositive, but it is relevant. As the court explained in Campbell, it is to be weighed against the degree to which the use has a further purpose or different character. The more transformative the new work, the less will be the significance of other factors, like commercialism, that may weigh against a finding of fair use. Second, the first factor also relates to the justification for the use. In a broad sense, a use that has a distinct purpose is justified because it furthers the goal of copyright, namely, to promote the progress of science and the arts without diminishing the incentive to create. The more the appropriator is using the copied material for new, transformative purposes, the more it serves copyright's goal of enriching public knowledge, and the less likely it is that the appropriation will serve as a substitute for the original or its plausible derivatives, shrinking the protected market opportunities of the copyrighted work. A use that shares the purpose of a copyrighted work, by contrast, is more likely to provide the public with a substantial substitute for matter protected by the copyright owner's interests in the original work or derivatives of it, which undermines the goal of copyright. In a narrower sense, a use may be justified because copying is reasonably necessary to achieve the user's new purpose. Parody, for example, needs to mimic an original to make its point. Similarly, other commentary or criticism that targets an original work may have compelling reason to conjure up the original by borrowing from it. An independent justification like this is particularly relevant to assessing fair use where an original work and copying use share the same or highly similar purposes, or where wide dissemination of a secondary work would otherwise run the risk of substitution for the original or licensed derivatives of it. Once again, the question of justification is one of degree. It is not sufficient simply to conclude whether or not justification exists. The question remains how powerful or persuasive is the justification, because the court must weigh the strength of the secondary user's justification against factors favoring the copyright owner. In sum, the first fair use factor considers whether the use of a copyrighted work has a further purpose or different character, which is a matter of degree, and the degree of difference must be balanced against the commercial nature of the use. If an original work and a secondary use share the same or highly similar purposes, and the secondary use is of a commercial nature, the first factor is likely to weigh against fair use, absent some other justification for copying. The fair use provision, and the first factor in particular, requires an analysis of the specific use of a copyrighted work that is alleged to be an infringement. The same copying may be fair when used for one purpose but not another. The sale of a parody for its own sake, let alone one performed a single time by students in school. Private home use. Here, Goldsmith's copyrighted photograph has been used in multiple ways. After Goldsmith licensed the photograph to Vanity Fair to serve as an artist reference, Warhol used the photograph to create the Vanity Fair illustration and the other print series works. Vanity Fair then used the photograph, pursuant to the license, when it published Warhol's illustration in 1984. Finally, AWF used the photograph when it licensed an image of Warhol's orange prints to Condé Nast in 2016. Only that last use, however, AWF's commercial licensing of orange prints to Condé Nast, is alleged to be infringing. We limit our analysis accordingly. In particular, the court expresses no opinion as to the creation, display, or sale of any of the original print series works. A typical use of a celebrity photograph is to accompany stories about the celebrity, often in magazines. For example, Goldsmith licensed her photographs of Prince to illustrate stories about Prince in magazines such as Newsweek, Vanity Fair, and People. She even licensed her photographs for that purpose after Prince died in 2016. A photographer may also license her creative work to serve as a reference for an artist, like Goldsmith did in 1984 when Vanity Fair wanted an image of Prince created by Warhol to illustrate an article about Prince. As noted by the Court of Appeals, Goldsmith introduced uncontroverted evidence that photographers generally license others to create stylized derivatives of their work in the vein of the Prince series. In fact, Warhol himself paid to license photographs for some of his artistic renditions. Such licenses for photographs or derivatives of them are how photographers like Goldsmith make a living. They provide an economic incentive to create original works, which is the goal of copyright. In 2016, AWF licensed an image of Orange Prince to Condé Nast to appear on the cover of a commemorative edition magazine about Prince. The edition, titled The Genius of Prince, celebrates the life and work of Prince Rogers Nelson, 1958 to 2016. It is undisputed here that the edition is devoted to Prince. In addition to AWF's image on the cover, the magazine contains numerous concert and studio photographs of Prince. In that context, the purpose of the image is substantially the same as that of Goldsmith's photograph. Both are portraits of Prince used in magazines to illustrate stories about Prince. Such environments are not distinct and different. AWF's licensing of the Orange Prince image thus superseded the objects, i.e., shared the objectives, of Goldsmith's photograph, even if the two were not perfect substitutes. The use also is of a commercial nature. Just as Goldsmith licensed her photograph to Vanity Fair for $400, AWF licensed Orange Prince to Condé Nast for $10,000. The undisputed commercial character of AWF's use, though not dispositive, tends to weigh against a finding of fair use. Taken together, these two elements, that Goldsmith's photograph and AWF's 2016 licensing of Orange Prince, share substantially the same purpose, and that AWF's use of Goldsmith's photo was of a commercial nature, counsel against fair use, absent some other justification for copying. That is, although a use's transformativeness may outweigh its commercial character, here, both elements point in the same direction. The foregoing does not mean, however, that derivative works borrowing heavily from an original cannot be fair uses. In Google, the court suggested that an artistic painting might, for example, fall within the scope of fair use even though it precisely replicates a copyrighted advertising logo to make a comment about consumerism. That suggestion refers to Warhol's works that incorporate advertising logos, such as the Campbell's Soup Can series. Yet not all of Warhol's works, nor all uses of them, give rise to the same fair use analysis. In fact, soup cans well illustrates the distinction drawn here. The purpose of Campbell's logo is to advertise soup. Warhol's canvases do not share that purpose. Rather, the Soup Can series uses Campbell's copyrighted work for an artistic commentary on consumerism, a purpose that is orthogonal to advertising soup. The use therefore does not supersede the objects of the advertising logo. Moreover, a further justification for Warhol's use of Campbell's logo is apparent. His Soup Can series targets the logo. That is, the original copyrighted work is, at least in part, the object of Warhol's commentary. It is the very nature of Campbell's copyrighted logo, well known to the public, designed to be reproduced, and a symbol of an everyday item for mass consumption that enables the commentary. Hence the use of the copyrighted work not only serves a completely different purpose, to comment on consumerism rather than to advertise soup, it also conjures up the original work to shed light on the work itself, not just the subject of the work. Here, by contrast, AWF's use of Goldsmith's photograph does not target the photograph, nor has AWF offered another compelling justification for the use. AWF contends, however, that the purpose and character of its use of Goldsmith's photograph weighs in favor of fair use, because Warhol's silkscreen image of the photograph, like the Campbell's Soup Can series, has a new meaning or message. The district court, for example, understood the Prince series works to portray Prince as an iconic, larger-than-life figure. AWF also asserts that the works are a comment on celebrity. In particular, Warhol's Prince series conveys the dehumanizing nature of celebrity. According to AWF, that new meaning or message which the Court of Appeals ignored, makes the use transformative in the fair use sense. We disagree? Campbell did describe a transformative use as one that alters the first work with new expression, meaning, or message. That description paraphrased Judge Laval's Law Review article, which referred to new information, new aesthetics, new insights and understandings. Judge Laval contrasted such additions with secondary uses that merely repackaged the original. But Campbell cannot be read to mean that Section 107(1) weighs in favor of any use that adds some new expression, meaning, or message. Otherwise, transformative use would swallow the copyright owner's exclusive right to prepare derivative works. Many derivative works, including musical arrangements, film and stage adaptations, sequels, spin-offs and others that recast, transform or adapt the original, add new expression, meaning or message, or provide new information, new aesthetics, new insights and understandings. That is an intractable problem for AWF's interpretation of transformative use. The first fair use factor would not weigh in favor of a commercial remix of Prince's Purple Rain, just because the remix added new expression or had a different aesthetic. A film or musical adaptation, like that of Alice Walker's The Color Purple, might win awards for its significant creative contribution, alter the meaning of a classic novel, and add important new expression, such as images, performances, original music and lyrics. But that does not in itself dispense with the need for licensing. Campbell is again instructive. 2 Live Crew's version of Orbison's song easily conveyed a new meaning or message. It also had a different aesthetic. Yet the court went further, examining whether and to what extent 2 Live Crew Z's song had the parodic purpose of commenting on the original or criticizing it. Parody is of course a kind of message. Moreover, the court considered what the words of the songs might have meant to determine whether parody reasonably could be perceived. But new meaning or message was not sufficient. If it had been, the court could have made quick work of the first fair use factor. Instead, meaning or message was simply relevant to whether the new use served a purpose distinct from the original, or instead superseded its objects. That was, and is, the central question under the first factor. The dissent commits the same interpretive error as AWF. It focuses on Campbell's paraphrase, yet ignores the rest of that decision's careful reasoning. Indeed, upon reading the dissent, someone might be surprised to learn that Campbell was about parody at all. Had expert testimony confirmed the obvious fact that 2 Live Crew Z Pretty Woman differed in aesthetics and meaning from Orbison's original, that would have been the end of the dissent's analysis. Not the court's, however. Campbell was the culmination of a long line of cases and scholarship about parody's claim to fairness in borrowing. For purposes of copyright law, the court explained, the heart of any parodist's claim to quote from existing material is the use of some elements of a prior author's composition to create a new one that, at least in part, comments on that author's works. Campbell thus drew a nuanced distinction between parody and satire. While parody cannot function unless it conjures up the original, satire can stand on its own 2 feet and so requires justification for borrowing. The objective meaning or message of 2 Live Crew Z's song was relevant to this inquiry into the reasons for copying, but any new expression, meaning, or message was not the test. What role meaning or message played in the Court of Appeals analysis here is not entirely clear. The court correctly rejected the idea that any secondary work that adds a new aesthetic or new expression to its source material is necessarily transformative. It also appeared correctly to accept that meaning or message is relevant to but not dispositive of purpose. Elsewhere, however, the Court of Appeals stated that the district judge should not assume the role of art critic and seek to ascertain the intent behind or meaning of the works at issue. That statement is correct in part. A court should not attempt to evaluate the artistic significance of a particular work, nor does the subjective intent of the user or the subjective interpretation of a court determine the purpose of the use. But the meaning of a secondary work, as reasonably can be perceived, should be considered to the extent necessary to determine whether the purpose of the use is distinct from the original. For instance, because the use comments on, criticizes, or provides otherwise unavailable information about the original. The district court determined that the Prince series works can reasonably be perceived to have transformed Prince from a vulnerable, uncomfortable person to an iconic, larger-than-life figure. To make that determination, the district court relied, in part, on testimony by Goldsmith that her photographs of Prince show that he is not a comfortable person, and that he is a vulnerable human being. An expert on Warhol, meanwhile, testified that the Prince series works depict Prince as a kind of icon or totem of something, a mask-like simulacrum of his actual existence. The Court of Appeals noted, correctly, that whether a work is transformative cannot turn merely on the stated or perceived intent of the artist, or the meaning or impression that a critic, or for that matter, a judge draws from the work. Otherwise, the law may well recognize any alteration as transformative. Quoting for Nimmer, copyright, whether the purpose and character of a use weighs in favor of fair use is, instead, an objective inquiry into what use was made, i.e., what the user does with the original work. Granting the district court's conclusion that Orange Prince reasonably can be perceived to portray Prince as iconic, whereas Goldsmith's portrayal is photorealistic, that difference must be evaluated in the context of the specific use at issue. The use is AWF's commercial licensing of Orange Prince to appear on the cover of Condé Nast's special commemorative edition. The purpose of that use is, still, to illustrate a magazine about Prince with a portrait of Prince, although the purpose could be more specifically described as illustrating a magazine about Prince with a portrait of Prince, one that portrays Prince somewhat differently from Goldsmith's photograph, yet has no critical bearing on her photograph. That degree of difference is not enough for the first factor to favor AWF, given the specific context of the use. To hold otherwise would potentially authorize a range of commercial copying of photographs, to be used for purposes that are substantially the same as those of the originals. As long as the user somehow portrays the subject of the photograph differently, he could make modest alterations to the original, sell it to an outlet to accompany a story about the subject, and claim transformative use. Many photographs will be open to various interpretations. A subject as open to interpretation as the human face, for example, reasonably can be perceived as conveying several possible meanings. The application of an artist's characteristic style to bring out a particular meaning that was available in the photograph is less likely to constitute a further purpose, as Campbell used the term. AWF asserts another, albeit related, purpose, which is to comment on the dehumanizing nature and effects of celebrity. No doubt, many of Warhol's works, and particularly his uses of repeated images, can be perceived as depicting celebrities as commodities. But again, even if such commentary is perceptible on the cover of Condé Nast's tribute to Prince Rogers Nelson, 1958-2016, on the occasion of the man's death, AWF has a problem. The asserted commentary is at Campbell's lowest ebb. Because it has no critical bearing on Goldsmith's photograph, the commentary's claim to fairness in borrowing from her work diminishes accordingly, if it does not vanish. The commercial nature of the use, on the other hand, looms larger. Here, the circumstances of AWF's 2016 licensing outweigh its diminished claim to fairness in copying under the first factor. Like satire that does not target an original work, AWF's asserted commentary can stand on its own 2 feet, and so requires justification for the very act of borrowing. Moreover, because AWF's commercial use of Goldsmith's photograph to illustrate a magazine about Prince is so similar to the photograph's typical use, a particularly compelling justification is needed. Yet AWF offers no independent justification, let alone a compelling one, for copying the photograph, other than to convey a new meaning or message. As explained, that alone is not enough for the first factor to favor fair use. Copying might have been helpful to convey a new meaning or message. It often is, but that does not suffice under the first factor. Nor does it distinguish AWF from a long list of would-be fair users, a musician who finds it helpful to sample another artist's song to make his own, a playwright who finds it helpful to adapt a novel, or a filmmaker who would prefer to create a sequel or spin-off, to name just a few. As Judge Laval has explained, a secondary author is not necessarily at liberty to make wholesale takings of the original author's expression merely because of how well the original author's expression would convey the secondary author's different message. The dissent would rather not debate these finer points. It offers no theory of the relationship between transformative uses of original works and derivative works that transform originals. No reason why AWF was justified in using Goldsmith's original work in this specific instance, and no limiting principle for its apparent position that any use that is creative prevails under the first fair use factor. Instead, the dissent makes the simple and obvious point that restrictions on copying can inhibit follow-on works. Nothing comes from nothing, the dissent observes. Nothing ever could. So, somewhere in the copyright statute there must be an escape valve to create something good. If AWF must pay Goldsmith to use her creation, the dissent claims, this will stifle creativity of every sort, thwart the expression of new ideas and the attainment of new knowledge, and make our world poorer. These claims will not age well. It will not impoverish our world to require AWF to pay Goldsmith a fraction of the proceeds from its reuse of her copyrighted work. Recall, payments like these are incentives for artists to create original works in the first place. Nor will the court's decision, which is consistent with long-standing principles of fair use, snuff out the light of Western civilization, returning us to the dark ages of a world without Titian, Shakespeare, or Richard Rogers. The dissent goes on at length about the basic premise that copyright, like other forms of intellectual property, involves a trade-off between stimulating innovative activity on the one hand, and allowing follow-on innovation on the other. This theme will be familiar to any student of copyright law. In tracing the history of Renaissance painting, however, the dissent loses sight of the statute and this court's cases. The Lives of the Artists undoubtedly makes for livelier reading than the U.S. Code or the U.S. reports, but as a court, we do not have that luxury. The dissent thus misses the forest for a tree. Its single-minded focus on the value of copying ignores the value of original works. It ignores the statute's focus on the specific use alleged to be infringing. It waves away the statute's concern for derivative works. It fails to appreciate Campbell's nuance, and it disregards this court's repeated emphasis on justification. The result of these omissions is an account of fair use that is unbalanced in theory and, perhaps relatedly, in tone. The dissent's conclusion, that whenever a use adds new meaning or message, or constitutes creative progress in the opinion of a critic or judge, the first fair use factor weighs in its favor, does not follow from its basic premise. Fair use instead strikes a balance between original works and secondary uses based in part on objective indicia of the use's purpose and character, including whether the use is commercial and, importantly, the reasons for copying. Finally, copyright law is replete with escape valves, the idea-expression distinction, the general rule that facts may not receive protection, the requirement of originality, the legal standard for actionable copying, the limited duration of copyright, and yes, the defense of fair use, including all its factors, such as whether the amount taken is reasonable in relation to the purpose of the use. These doctrines, and others, provide ample space for artists and other creators to use existing materials to make valuable new works. They account for most, if not all, of the examples given by the dissent, as well as the dissent's own copying, and the court's too. If the last century of American art, literature, music, and film is any indication, The existing copyright law, of which today's opinion is a continuation, is a powerful engine of creativity. Lynn Goldsmith's original works, like those of other photographers, are entitled to copyright protection, even against famous artists. Such protection includes the right to prepare derivative works that transform the original. The use of a copyrighted work may nevertheless be fair if, among other things, the use has a purpose and character that is sufficiently distinct from the original. In this case, however, Goldsmith's original photograph of Prince and AWF's copying use of that photograph, in an image licensed to a special edition magazine devoted to Prince, share substantially the same purpose, and the use is of a commercial nature. AWF has offered no other persuasive justification for its unauthorized use of the photograph. Therefore, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes, weighs in Goldsmith's favor. The court has cautioned that the four statutory fair use factors may not be treated in isolation, one from another. All are to be explored, and the results weighed together, in light of the purposes of copyright. AWF does not challenge the Court of Appeal's determinations that the second factor, the nature of the copyrighted work, third factor, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and fourth factor, the effect of the use upon the potential market for or value of the copyrighted work, all favor Goldsmith. Because this court agrees with the Court of Appeals that the first factor likewise favors her, the judgment of the Court of Appeals is affirmed. Justice Gorsuch, with whom Justice Jackson joins, concurring. The question before us is a narrow one of statutory interpretation. It concerns the meaning of one of four factors Congress has instructed courts to consult when a party invokes the affirmative defense of fair use to a claim of copyright infringement. The statutory factor in question requires courts to consider the purpose and character of the use. 17 U.S.C. Section 1071. The parties disagree which purpose and character counts. On the Foundation's telling, the statute requires courts to focus on the purpose the creator had in mind when producing his work and the character of his resulting work. So what matters in this case is that Andy Warhol intended to apply a new aesthetic to Lynn Goldsmith's photograph, and the character of his work transformed Prince from the vulnerable, uncomfortable person depicted in Ms. Goldsmith's photograph into an iconic, larger-than-life figure. Because the purpose and character of Mr. Warhol's work is so different from Ms. Goldsmith's, the Foundation insists, the first statutory factor points in favor of finding a fair use affirmative defense. By contrast, on Ms. Goldsmith's reading of the law and under the Second Circuit's approach, the first fair use factor requires courts to assess the purpose and character of the challenged use. The Foundation now owns Mr. Warhol's image of Prince, and it recently sought to license that image to a magazine looking for a depiction of Prince to accompany an article about Prince. Ms. Goldsmith seeks to license her copyrighted photograph to exactly these kinds of buyers. And because the purpose and character of the Foundation's challenged use, and the purpose and character of her own protected use overlap so completely, Ms. Goldsmith argues that the first statutory factor does not support a fair use affirmative defense. As I see it, the second view of the law is the better one. Nothing in the copyright statute calls on judges to speculate about the purpose an artist may have in mind when working on a particular project. Nothing in the law requires judges to try their hand at art criticism and assess the aesthetic character of the resulting work. Instead, the first statutory fair use factor instructs courts to focus on the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Section 1071, emphases added. By its terms, the law trains our attention on the particular use under challenge, and it asks us to assess whether the purpose and character of that use is different from, and thus complements, or is the same as, and thus substitutes for, a copyrighted work. It's a comparatively modest inquiry focused on how and for what reason a person is using a copyrighted work in the world, not on the moods of any artist or the aesthetic quality of any creation. To my mind, three contextual clues confirm that this reading of the statutory text is the correct one. First, the statutory preamble to all four fair use factors instructs courts to assess whether the person asserting a fair use defense seeks to use a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. Section 107, emphasis added. Once more, the statute indicates that a court must examine the purpose of the particular use under challenge, not the artistic purpose underlying a work. And once more, the statute tasks courts with asking whether the challenged use serves a different purpose, as, say, a criticism of or comment on the original, or whether it seeks to serve the same purpose, as a substitute for the original. Second, the copyright statute expressly protects a copyright holder's exclusive right to create derivative works that transform or adapt his original work. Sections 101, 106(2). so saying that a later user of a copyrighted work transformed its message and endowed it with a new aesthetic cannot automatically mean he has made fair use of it. To hold otherwise would risk making a nonsense of the statutory scheme, suggesting that transformative uses of originals belong to the copyright holder, under Section 106, but that others may simultaneously claim those transformative uses for themselves, under Section 107. We aren't normally in the business of putting a statute at war with itself in this way. Finally, the fourth fair use factor requires courts to assess the effect of the use upon the potential market for or value of the copyrighted work. Section 107(4). This court has described the fourth factor as the most important one. This court has said too that no factor may be treated in isolation, one from another. Nor does anything in the fourth factor call on courts to speculate about artistic ambitions or aesthetics. Instead, it requires courts to ask whether consumers treat a challenged use as a market replacement for a copyrighted work, or a market complement that does not impair demand for the original. Reading Section 107 as a whole, then, it supplies courts with a sequential chain of questions about the particular challenged use, starting with its purpose and character, in the first factor, and ending with its effect, in the fourth. There is no double counting here. Instead, the statute proceeds from step to step, asking judges to assess whether the challenged use, as revealed by its purpose, character, amount of source material used, and effect, serves as a complement to or a substitute for a copyrighted work. With all this in mind, the court's decision seems to me exactly right. Does Mr. Warhol's image seek to depict Prince as a larger-than-life icon, while Ms. Goldsmith's photograph attempts to cast him in a more vulnerable light? Or are the artistic purposes latent in the two images and their aesthetic character actually more similar than that? Happily, the law does not require judges to tangle with questions so far beyond our competence. Instead, the first fair use factor requires courts to assess only whether the purpose and character of the challenged use is the same as a protected use. And here, the undisputed facts reveal that the foundation sought to use its image as a commercial substitute for Ms. Goldsmith's photograph. Of course, competitive products often differ in material respects, and a buyer may find these differences reason to prefer one offering over another. But under the first fair use factor, the salient point is that the purpose and character of the foundation's use involved competition with Ms. Goldsmith's image. To know that much is to know the first fair use factor favors Ms. Goldsmith. It is equally important, however, to acknowledge what this case does not involve, and what the court does not decide. Worried about the fate of artists seeking to portray reclining nudes or papal authorities, or authors hoping to build on classic literary themes? Worry not. This case does not call on us to strike a balance between rewarding creators and enabling others to build on their work. That is Congress's job. Nor does this case even call on us to interpret and apply many of the reticulated elements of the Copyright Act that Congress has adopted to balance these competing interests. Our only job today is to interpret and apply faithfully one statutory factor among many Congress has deemed relevant to the affirmative defense of fair use. That observation points the way to another. The court today does not even decide whether the foundation's image of Prince infringes on Ms. Goldsmith's copyright. To uphold a claim of infringement under the Copyright Act, a court must find the defendant copied elements of the plaintiff's work that are themselves original. As part of this process, a court must isolate and vindicate only the truly original elements of a copyrighted work. The plaintiff must usually show not only a similarity but a substantial similarity between the allegedly infringing work and the original elements of his own copyrighted work. And even when two works are substantially similar, if both the plaintiff's and the defendant's works copy from a third source, reworking, say, a traditional artistic or literary theme, a claim for infringement generally will not succeed. In this case, we address none of these questions or other elements of the infringement standard designed to ensure room for later artists to build on the work of their predecessors. The district court concluded that it need not address the merits of Ms. Goldsmith's infringement claim, because the foundation could prevail at summary judgment on its affirmative defense of fair use. The Second Circuit reversed, focused primarily on the district court's application of the four fair use factors, and this court granted review to decide only the question of fair use and only the role of a single factor in that affirmative defense. Last but hardly least, while our interpretation of the first fair use factor does not favor the foundation in this case, it may in others. If, for example, the foundation had sought to display Mr. Warhol's image of Prince in a non-profit museum or a for-profit book commenting on 20th century art, the purpose and character of that use might well point to fair use. But those cases are not this case. Before us, Ms. Goldsmith challenges only the foundation's effort to use its portrait as a commercial substitute for her own protected photograph in sales to magazines looking for images of Prince to accompany articles about the musician. And our only point today is that, while the foundation may often have a fair use defense for Mr. Warhol's work, that does not mean it always will. Under the law Congress has given us, each challenged use must be assessed on its own terms. Justice Kagan, with whom the Chief Justice joins, dissenting. Today, the court declares that Andy Warhol's eye-popping silkscreen of Prince, a work based on but dramatically altering an existing photograph, is, in copyright lingo, not transformative. Still more, the court decides that even if Warhol's portrait were transformative, even if its expression and meaning were worlds away from the photo, that fact would not matter. For in the majority's view, copyright law's first fair use factor, addressing the purpose and character of the use made of a work, is uninterested in the distinctiveness and newness of Warhol's portrait. You've probably heard of Andy Warhol. You've probably seen his art. You know that he reframed and reformulated, in a word, transformed, images created first by others. Campbell's soup cans and Brillo boxes, photos of celebrity icons, Marilyn, Elvis, Jackie, Liz, and, as most relevant here, Prince. That's how Warhol earned his conspicuous place in every college's art history 101. So it may come as a surprise to see the majority describe the Prince silkscreen as a modest alteration of Lynn Goldsmith's photograph, the result of some cropping and flattening with the same essential nature, or, more generally, to observe the majority's lack of appreciation for the way his works differ in both aesthetics and message from the original templates. In a recent decision, this court used Warhol paintings as the perfect exemplar of a copying use that adds something new and important, of a use that is transformative, and thus points toward a finding of fair use. That court would have told this one to go back to school. What is worse, that refresher course would apparently be insufficient. For it is not just that the majority does not realize how much Warhol added, it is that the majority does not care. In adopting that posture of indifference, the majority does something novel, though in law, unlike in art, it is rarely a good thing to be transformative. Before today, we assess the purpose and character of a copier's use by asking the following question: does the work add something new, with a further purpose or different character, altering the original with new expression, meaning, or message? When it did so to a significant degree, we called the work transformative, and held that the fair use test's first factor favored the copier, though other factors could outweigh that one. But today's decision, all the majority's protestations notwithstanding, leaves our first factor inquiry in shambles. The majority holds that because Warhol licensed his work to a magazine, as Goldsmith sometimes also did, the first factor goes against him. It does not matter how different the Warhol is from the original photo, how much new expression, meaning, or message he added. It does not matter that the silkscreen and the photo do not have the same aesthetic characteristics and do not convey the same meaning. It does not matter that, because of those dissimilarities, the magazine publisher did not view the one as a substitute for the other. All that matters is that Warhol and the publisher entered into a licensing transaction, similar to one Goldsmith might have done. Because the artist had such a commercial purpose, all the creativity in the world could not save him. That doctrinal shift ill serves copyright's core purpose. The law does not grant artists and authors and composers and so on exclusive rights, that is, monopolies for their own sake. It does so to foster creativity, to promote the progress of both arts and science. And for that same reason, the law also protects the fair use of copyrighted material. Both Congress and the courts have long recognized that an overly stringent copyright regime actually stifles creativity by preventing artists from building on the work of others. For, let's be honest, artists don't create all on their own. They cannot do what they do without borrowing from or otherwise making use of the work of others. That is the way artistry of all kinds, visual, musical, literary, happens, as it is the way knowledge and invention generally develop. The fair use test's first factor responds to that truth, as understood in our precedent. It provides breathing space for artists to use existing materials to make fundamentally new works, for the public's enjoyment and benefit. In now remaking that factor and thus constricting fair use's boundaries, the majority hampers creative progress and undermines creative freedom. I respectfully dissent. Andy Warhol is the avatar of transformative copying. In his early career, Warhol worked as a commercial illustrator and became experienced in varied techniques of reproduction. By night, he used those techniques, in particular the silkscreen, to create his own art. The silkscreen enabled him to make brilliantly novel art out of existing images carefully selected from popular culture. The works he produced, connecting traditions of fine art with mass culture, depended on appropriations. The use of elements of an extant image is Warhol's entire modus operandi. And with that MO, he changed modern art. His appropriations and his originality were flip sides of each other. To a public accustomed to thinking of art as formal works belonging in gold frames disconnected from the everyday world of products and personalities, Warhol's paintings landed like a thunderclap. Think soup cans, or in another vein, think Elvis. Warhol had created something very new, shockingly important, transformative art. To see the method in action, consider one of Warhol's pre-Prince celebrity silkscreens, this one, of Marilyn Monroe. He began with a publicity photograph of the actress, and then he went to work. He reframed the image, zooming in on Monroe's face to produce the disembodied effect of a cinematic close-up. At that point, he produced a high-contrast, flattened image on a sheet of clear acetate. He used that image to trace an outline on the canvas, and he painted on top, applying exotic colors with a flat, even consistency and an industrial appearance. The same high-contrast image was then reproduced in negative on a silkscreen, designed to function as a selectively porous mesh. Warhol would place the screen face down on the canvas, pour ink onto the back of the mesh, and use a squeegee to pull the ink through the weave and onto the canvas. On some of his Marilyns, there are many, he reordered the process, first ink, then color, then, perhaps, ink again. The result, see for yourself, is miles away from a literal copy of the publicity photo. Andy Warhol, Marilyn, 1964, acrylic and silkscreen ink on linen. And the meaning is different from any the photo had. Of course, meaning in great art is contestable and contested, as is the premise that an artwork is great. But note what some experts say about the complex messages Warhol's Marilyns convey. On one level, those vivid, larger-than-life paintings are celebrity iconography, making a secular, profane subject transcendent and eternal. But they also function as a biting critique of the cult of celebrity and the role it plays in American life. With misaligned, day-glow colors suggesting artificiality and industrial production, Warhol portrayed the actress as a consumer product, and in so doing, he exposed the deficiencies of a mass media culture in which such superficial icons loom so large. Out of a publicity photo came both memorable portraiture and pointed social commentary. As with Marilyn, similarly with Prince. In 1984, Vanity Fair commissioned Warhol to create a portrait based on a black-and-white photograph taken by noted photographer Lynn Goldsmith. As he did in the Marilyn series, Warhol cropped the photo, so that Prince's head fills the whole frame. It thus becomes disembodied, as if magically suspended in space. And as before, Warhol converted the cropped photo into a higher contrast image, incorporated into a silkscreen. That image isolated and exaggerated the darkest details of Prince's head. It also reduced his natural, angled position, presenting him in a more face-forward way. Warhol traced, painted, and inked, as earlier described. He also made a second silkscreen. Based on his tracings, the ink he passed through that screen left differently colored, out-of-kilter lines around Prince's face and hair, a bit hard to see in the reproduction below, more pronounced in the original. Altogether, Warhol made 14 prints and 2 drawings, the Prince series, in a range of unnatural, lurid hues. Vanity Fair chose the purple Prince to accompany an article on the musician. 32 years later, just after Prince died, Condé Nast paid Warhol to use the orange Prince on the cover of a special commemorative magazine. A picture or two, as the saying goes, is worth 1,000 words, so here is what those magazines published. Andy Warhol, Prince, 1984, synthetic paint and silkscreen ink on canvas. It does not take an art expert to see a transformation, but in any event, all those offering testimony in this case agreed there was one. The experts explained, in far greater detail than I have, the laborious and painstaking work that Warhol put into these and other portraits. They described, in ways I have tried to suggest, the resulting visual differences between the photo and the silkscreen. As one summarized the matter, the two works are materially distinct in their composition, presentation, color palette, and media I.E. in pretty much all their aesthetic traits. And with the change in form came an undisputed change in meaning. Goldsmith's focus, seen in what one expert called the corporeality and luminosity of her depiction, was on Prince's unique human identity. Warhol's focus was more nearly the opposite. His subject was not the private person but the public image. The artist's flattened, cropped, exotically colored, and unnatural depiction of Prince's disembodied head sought to communicate a message about the impact of celebrity in contemporary life. On Warhol's canvas, Prince emerged as spectral, dark, and uncanny, less a real person than a mask-like simulacrum. He was reframed as a larger-than-life icon or totem, yet he was also reduced. He became the product of a publicity machine that packages and disseminates commoditized images. He manifested, in short, the dehumanizing culture of celebrity in America. The message could not have been more different. A thought experiment may pound the point home. Suppose you were the editor of Vanity Fair or Condé Nast, publishing an article about Prince. You need, of course, some kind of picture. An employee comes to you with 2 options: the Goldsmith photo, the Warhol portrait. Would you say that you don't really care? That the employee is free to flip a coin? In the majority's view, you apparently would. Its opinion, as further discussed below, is built on the idea that both are just portraits of Prince that may equivalently be used to depict Prince in magazine stories about Prince. All I can say is that it's a good thing the majority isn't in the magazine business. Of course you would care. You would be drawn aesthetically to one, or instead to the other. You would want to convey the message of one, or instead of the other. The point here is not that one is better and the other worse. The point is that they are fundamentally different. You would see them not as substitutes, but as divergent ways to, in the majority's mantra, illustrate a magazine about Prince with a portrait of Prince. Or else you, like the majority, would not have much of a future in magazine publishing. In any event, the editors of Vanity Fair and Condé Nast understood the difference, the gulf in both aesthetics and meaning between the Goldsmith photo and the Warhol portrait. They knew about the photo, but they wanted the portrait. They saw that, as between the two works, Warhol had effected a transformation. The question in this case is whether that transformation should matter in assessing whether Warhol made fair use of Goldsmith's copyrighted photo. The answer is yes, it should push toward, although not dictate, a finding of fair use. That answer comports with the copyright statute, its underlying policy, and our precedent concerning the two. Under established copyright law, until today, Warhol's addition of important new expression, meaning, and message counts in his favor in the fair use inquiry. Start by asking a broader question: why do we have fair use anyway? The majority responds that while copyrights encourage the making of creative works, fair use promotes their public availability. But that description sells fair use far short. Beyond promoting availability, fair use itself advances creativity and artistic progress. This court has long understood the point has gotten how new art, new invention, and new knowledge arise from existing works. Our seminal opinion on fair use quoted the illustrious Justice story. In truth, in literature, in science, and in art, there are, and can be, few, if any, things which are strictly new and original throughout. Every book in literature, science, and art borrows, and must necessarily borrow, and use much which was well known and used before. Because that is so, a copyright regime with no escape valves would stifle the very creativity which the law is designed to foster. Fair use is such an escape valve. It allows others to build upon copyrighted material, so as not to put manacles upon creative progress. In short, copyright's core value, promoting creativity, sometimes demands a pass for copying. To identify when that is so, the courts developed and Congress later codified a multifactored inquiry. As the majority describes, the current statute sets out 4 non-exclusive considerations to guide courts. They are: 1. The purpose and character of the use made of the copyrighted work, including whether such use is of a commercial nature. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. Those factors sometimes point in different directions. If so, a court must weigh them against each other. In doing so, we have stated, courts should view the 4th factor, which focuses on the copyright holder's economic interests, as the most important. But the overall balance cannot come out right unless each factor is assessed correctly. This case, of course, is about, and only about, the first. And that factor is distinctive. It is the only one that focuses on what the copier's use of the original work accomplishes. The first factor asks about the character of that use, its main or essential nature, especially as strongly marked and serving to distinguish. And the first factor asks about the purpose of the use, the object, effect, or result aimed at, intended, or attained. In that way, the first factor gives the copier a chance to make his case. Look, the copier can say, at how I altered the original, and what I achieved in so doing. Look at how the original was used as raw material and was transformed in the creation of new information, new aesthetics, new insights. That is hardly the end of the fair use inquiry. Commercialism too may bear on the first factor. And anyway, there are 3 factors to go. But it matters profoundly. Because when a transformation of the original work has occurred, the user of the work has made the kind of creative contribution that copyright law has as its object. Don't take it from me, the above is exactly what this court has held about how to apply factor 1. In Campbell, our primary case on the topic, we stated that the first factor's purpose and character test centrally concerns whether and to what extent the new work is transformative. That makes sense, we explained, because the goal of copyright, to promote science and the arts, is generally furthered by the creation of transformative works. We then expounded on when such a transformation happens. Harking back to Justice's story, we explained that a new work might merely supersede the objects of the original creation, meaning that it does no more, and for no other end, than the first work had. But alternatively, the new work could add something new, with a further purpose or different character, altering the first with new expression, meaning, or message. Forgive me, but given the majority's stance, that bears repeating. The critical factor 1 inquiry, we held, is whether a new work alters the first with new expression, meaning, or message. The more it does so, the more transformative the new work. And, here's the final takeaway, the more transformative the new work, the less will be the significance of other factors, like commercialism, that may weigh against a finding of fair use. Under that approach, the Campbell court held, the rap group 2 Live Crew Z transformative copying of Roy Orbison's Pretty Woman counted in favor of fair use. And that was so even though the rap song was, as everyone agreed, recorded and later sold for profit. Just 2 terms ago, in Google, we made all the same points. We quoted Campbell in explaining that the Factor 1 inquiry is whether the copier's use adds something new, with a further purpose or different character, altering the copyrighted work with new expression, meaning, or message. We again described a copying use that adds something new and important as transformative. We reiterated that protecting transformative uses stimulates creativity and thus fulfills the objective of copyright law. And then we gave an example. Yes, of course, we pointed to Andy Warhol. The majority claims not to be embarrassed by this embarrassing fact, because the specific reference was to his soup cans, rather than his celebrity images. But drawing a distinction between a commentary on consumerism, which is how the majority describes his soup canvases, and a commentary on celebrity culture, i.e., the turning of people into consumption items, is slicing the bologna pretty thin. Finally, the court conducted the first factor inquiry it had described. Google had replicated Sun Microsystems' computer code as part of a commercial endeavor done for commercial profit. No matter, said the court. Many common fair uses are indisputably commercial. What mattered instead was that Google had used Sun's code to make something new and important, a highly creative and innovative software platform. The use of the code, the court held, was therefore transformative and pointed toward fair use. Campbell and Google also illustrate the difference it can make in the world to protect transformative works through fair use. Easy enough to say, as the majority does, that a follow-on creator should just pay a licensing fee for its use of an original work. But sometimes copyright holders charge an out-of-range price for licenses, and other times they just say no. In Campbell, for example, Orbison's successor in interest turned down 2 Live Crew Z's request for a license, hoping to block the rap takeoff of the original song. And in Google, the parties could not agree on licensing terms, as Sun insisted on conditions that Google thought would have subverted its business model. So without fair use, 2 Live Crew Z and Google's works, however new and important, might never have been made, or, if made, never have reached the public. The prospect of that loss to creative progress is what lay behind the court's inquiry into transformativeness, into the expressive novelty of the follow-on work, regardless whether the original creator granted permission. Now recall all the ways Warhol, in making a Prince portrait from the Goldsmith photo, added something new, with a further purpose or different character, all the ways he altered the original work's expression, meaning, and message. The differences in form and appearance, relating to composition, presentation, color palette, and media. The differences in meaning that arose from replacing a realistic and indeed humanistic depiction of the performer with an unnatural, disembodied mask-like one. The conveyance of new messages about celebrity culture and its personal and societal impacts. The presence of, in a word, transformation, the kind of creative building that copyright exists to encourage. Warhol's use, to be sure, had a commercial aspect. Like most artists, Warhol did not want to hide his works in a garret. He wanted to sell them. But as Campbell and Google both demonstrate, and as further discussed below, that fact is nothing near the showstopper the majority claims. Remember, the more transformative the work, the less commercialism matters. The dazzling creativity evident in the Prince portrait might not get Warhol all the way home in the fair use inquiry. There remain other factors to be considered and possibly weighed against the first one. But the purpose and character of Warhol's use of the copyrighted work, what he did to the Goldsmith photo, in service of what objects, counts powerfully in his favor. He started with an old photo, but he created a new thing. The majority does not see it, and I mean that literally. There is precious little evidence in today's opinion that the majority has actually looked at these images, much less that it has engaged with expert views of their aesthetics and meaning. Whatever new expression Warhol added, the majority says, was not transformative. Apparently, Warhol made only modest alterations. Anyone, the majority suggests, could have cropped, flattened, traced, and colored the photo as Warhol did. True, Warhol portrayed Prince somewhat differently, but the degree of difference is too small. It consists merely in applying Warhol's characteristic style and aesthetic gloss, if you will, to bring out a particular meaning that was already available in Goldsmith's photograph. So too, Warhol's commentary on celebrity culture matters not at all. The majority is not willing to concede that it even exists. And as for the district court's view that Warhol transformed Prince from a vulnerable, uncomfortable person to an iconic, larger-than-life figure, the majority is downright dismissive. Vulnerable? Iconic? Who cares? The silkscreen and the photo, the majority claims, still have the same essential nature. The description is disheartening. It's as though Warhol is an Instagram filter, and a simple one at that. For example, sepia tinting. What is all the fuss about? The majority wants to know. Ignoring reams of expert evidence explaining, as every art historian could explain, exactly what the fuss is about, the majority plants itself firmly in the eye could paint that school of art criticism. No wonder the majority sees the two images as essentially fungible products in the magazine market. Publish this one, publish that one. What does it matter? The problem is that it does matter, for all the reasons given in the record and discussed above. Warhol based his silkscreen on a photo, but fundamentally changed its character and meaning. In belittling those creative contributions, the majority guarantees that it will reach the wrong result. Worse still, the the majority maintains that those contributions, even if significant, just would not matter. All of Warhol's artistry and social commentary is negated by one thing: Warhol licensed his portrait to a magazine, and Goldsmith sometimes licensed her photos to magazines too. That is the sum and substance of the majority opinion. Over and over, the majority incants that both works are portraits of Prince used in magazines to illustrate stories about Prince. They therefore both share substantially the same purpose, meaning a commercial one. Or said otherwise, because Warhol entered into a licensing transaction with Condé Nast, he could not get any help from Factor 1, regardless how transformative his image was. The majority's commercialism trumps creativity analysis has only one way out. If Warhol had used Goldsmith's photo to comment on or critique Goldsmith's photo, he might have availed himself of that factor's benefit, though why anyone would be interested in that work is mysterious. But because he instead commented on society, the dehumanizing culture of celebrity, he is, go figure, out of luck. From top to bottom, the analysis fails. It does not fit the copyright statute. It is not faithful to our precedent. And it does not serve the purpose both Congress and the court have understood to lie at the core of fair use, stimulating creativity, by enabling artists and writers of every description to build on prior works. That is how art, literature, and music happen. It is also how all forms of knowledge advance. Even as the majority misconstrues the law, it misunderstands and threatens the creative process. Start with what the statute tells us about whether the Factor 1 inquiry should disregard Warhol's creative contributions because he licensed his work. Sneak preview? It shouldn't. The majority claims the text as its strong suit, viewing our precedent's inquiry into new expression and meaning as a faulty paraphrase of the statutory language. But it is the majority, not Campbell and Google, that misreads Section 1071. First, the key term character plays little role in the majority's analysis. When referring to the character of what Warhol did, the majority says merely that he licensed Orange Prince to Condé Nast for $10,000. But that reductionist view rids the term of most of its ordinary meaning. Character typically refers to a thing's main or essential nature, especially as strongly marked and serving to distinguish. Webster's Third 376, the essential and distinctive nature of an artist's use of a work commonly involves artistry as it did here. So the term character makes significant everything the record contains and everything everyone, save the majority, knows about the differences in expression and meaning between Goldsmith's photo and Warhol's silkscreen. Second, the majority significantly narrows Section 1071's reference to purpose, thereby paralleling its constriction of character. It might be obvious to you that artists have artistic purposes, and surely it was obvious to the drafters of a law aiming to promote artistic and other kinds of creativity, but not to the majority, which again cares only about Warhol's decision to license his art. Warhol's purpose, the majority says, was just to depict Prince in a magazine story about Prince in exchange for money. The majority spurns all that mattered to the artist evident on the face of his work about expression, meaning, and message. That indifference to purposes beyond the commercial for what an artist, most fundamentally, wants to communicate finds no support in Section 1071. Still more, the majority's commercialism uber alles view of the Factor 1 inquiry fits badly with two other parts of the fair use provision. To begin, take the preamble, which gives examples of uses often thought: fair, criticism, comment, news reporting, teaching, scholarship, or research. As we have explained, an emphasis on commercialism would swallow those uses, that is, would mostly deprive them of fair use protection. For the listed activities are generally conducted for profit in this country. No man but a blockhead, Samuel Johnson once noted, ever wrote except for money. And Congress of course knew that when it drafted the preamble. Next, skip to the last factor in the fair use test, the effect of the use upon the potential market for or value of the copyrighted work. You might think that when Congress lists two different factors for consideration, it is because the two factors are, well, different. But the majority transplants Factor 4 into Factor 1. Recall that the majority conducts a kind of market analysis. Warhol, the majority says, licensed his portrait of Prince to a magazine that Goldsmith could have licensed her photo to, and so may have caused her economic harm. That issue is no doubt important in the fair use inquiry. But it is the stuff of Factor 4, how Warhol's use affected the value of or market for Goldsmith's photo. Factor 1 focuses on the other side of the equation, the new expression, meaning, or message that may come from someone else using the original. Under the statute, courts are supposed to strike a balance between the two, and thus between rewarding original creators and enabling others to build on their works. That cannot happen when a court, a la the majority, double counts the first goal and ignores the second. Is it possible I overstate the matter? I would like for that to be true. And a puzzling aspect of today's opinion is that it occasionally acknowledges the balance that the fair use provision contemplates. So, for example, the majority notes after reviewing the relevant text that the central question the first factor asks is whether the new work adds something new to the copyrighted one. Yes, exactly. And in other places, the majority suggests that a court should consider in the Factor 1 analysis not merely the commercial context, but also the copier's addition of new expression, including new meaning or message. In that way, the majority opinion differs from Justice Gorsuch's concurrence, which would exclude all inquiry into whether a follow-on work is transformative. And it is possible lower courts will pick up on that difference, and ensure that the newness of a follow-on work will continue to play a significant role in the Factor 1 analysis. If so, I'll be happy to discover that my claims have not aged well. But that would require courts to do what the majority does not: make a serious inquiry into the follow-on artist's creative contributions. The majority's refusal to do so is what creates the oddity at the heart of today's opinion. If newness matters, as the opinion sometimes says, then why does the majority dismiss all the newness Warhol added just because he licensed his portrait to Condé Nast? And why does the majority insist more generally that in a commercial context conveying a new meaning or message is not enough for the first factor to favor fair use? Certainly not because of our precedent, which conflicts with nearly all the majority says. As explained earlier, this court has decided two important cases about Factor 1. In each, the copier had built on the original to make a product for sale, so the use was patently commercial. And in each, that fact made no difference, because the use was also transformative. The copier, we held, had made a significant creative contribution, had added real value. So in Campbell, we did not ask whether 2 Live Crew and Roy Orbison both meant to make money by including a catchy song about women on a record album. We instead asked whether 2 Live Crew had added significant new expression, meaning, and message. And because we answered yes, we held that the group's rap song did not merely supersede the objects of the original creation. Similarly, in Google, we took for granted that Google, the copier, and Sun, the original author, both meant to market software platforms facilitating the same tasks, just as Warhol and Goldsmith both wanted to market images depicting the same subject. So what was our basic response? Google's copying had enabled the company to make a highly creative and innovative tool, advancing creative progress, and thus serving the basic constitutional objective of copyright. Search today's opinion high and low, you will see no such awareness of how copying can help produce valuable new works. Nor does our precedent support the majority's strong distinction between follow-on works that target the original and those that do not. Even the majority does not claim that anything in the text does so. True enough that the rap song in Campbell fell into the former category, 2 Live Crew urged that its work was a parody of Orbison's song. But even in discussing the value of parody, Campbell made clear the limits of targeting's importance. The court observed that as the extent of transformation increases, the relevance of targeting decreases. Google proves the point. The new work there did not parody, comment on, or otherwise direct itself to the old. The former just made use of the latter for its own devices. Yet that fact never made an appearance in the court's opinion. What mattered instead was the highly creative use Google had made of the copied code. That decision is on point here. Would Warhol's work really have been more worthy of protection if it had, somehow, shed light on Goldsmith's photograph, rather than on Prince, his celebrity status and celebrity culture? Would that Goldsmith-focused work, whatever it might be, have more meaningfully advanced creative progress, which is copyright's raison d'etre, than the work he actually made? I can't see how. More like the opposite. The majority's preference for the directed work, apparently on grounds of necessity, again reflects its undervaluing of transformative copying as a core part of artistry. And there's the rub. As Congress knew, and as this court once saw, new creations come from building on and, in the process, transforming those coming before. Today's decision stymies and suppresses that process, in art and every other kind of creative endeavor. The decision enhances a copyright holder's power to inhibit artistic development, by enabling her to block even the use of a work to fashion something quite different. Or viewed the other way round, the decision impedes non-copyright holders' artistic pursuits, by preventing them from making even the most novel uses of existing materials. On either account, the public loses. The decision operates to constrain creative expression. The effect, moreover, will be dramatic. Return again to Justice's story. In literature, in science and in art, there are, and can be, few, if any, things that are new and original throughout. Every work borrows, and must necessarily do so. Creators themselves know that fact deep in their bones. Here is Mark Twain on the subject. The kernel, the soul. Let us go further and say the substance, the bulk, the actual and valuable material of creative works, all are consciously and unconsciously drawn from a million outside sources. Appropriation, mimicry, quotation, allusion and sublimated collaboration, novelist Jonathan Lethem has explained, are a kind of sine qua non of the creative act, cutting across all forms and genres in the realm of cultural production. Or, as Mary Shelley once wrote, there is no such thing as creating out of a void. Consider, in light of those authorial references, how the majority's Factor 1 analysis might play out in literature. And why not start with the best? Shakespeare borrowed over and over and over. I could point to a whole slew of works, but let's take Romeo and Juliet as an example. Shakespeare's version copied most directly from Arthur Brooks' The Tragical History of Romeus and Juliet, written a few decades earlier. Shakespeare took plot, characters, themes, even passages. The friar's line to Romeo, "Art thou a man? Thy form cries out thou art," appeared in Brooke as "Art thou a man? The shape saith so thou art," Bullo 387. Shakespeare was, among other things, a good editor. Of course, Shakespeare also added loads of genius, and so made the borrowed stories uniquely Shakespearean. But on the majority's analysis, the two works Shakespeare's and Brooks are just two stories of star-crossed lovers written for commercial gain. Shakespeare would not qualify for fair use. He would not even come out ahead on Factor 1. And if you think that's just Shakespeare, here are a couple more. Lolita, though hard to read today, is usually thought one of the greatest novels of the 20th century. But the plotline: an adult man takes a room as a lodger, embarks on an obsessive sexual relationship with the preteen daughter of the house, and eventually survives her death, remaining marked forever, appears in a story by Heinz von Lechberg written a few decades earlier. Oh, and the girl's name is Lolita in both versions. All that said, the two works have little in common artistically. Nothing literary critics admire in the second Lolita is found in the first. But to the majority, just two stories of revoltingly lecherous men published for profit. So even Factor 1 of the fair use inquiry would not aid Nabokov, or take one of the most famed adventure stories ever told. Here is the provenance of Treasure Island, as Robert Louis Stevenson himself described it. No doubt the parrot once belonged to Robinson Crusoe. No doubt the skeleton is conveyed from Edgar Allan Poe. I think little of these. They are trifles and details, and no man can hope to have a monopoly of skeletons or make a corner in talking birds. It is my debt to Washington Irving that exercises my conscience, and justly so, for I believe plagiarism was rarely carried farther. Billy Bones, his chest, the company in the parlor, the whole inner spirit, and a good deal of the material detail of my first chapters, all were there. All were the property of Washington Irving. Odd that a book about pirates should have practiced piracy? Not really, because tons of books do, and not many in order to target or otherwise comment on the originals. Thomas Mann, himself a master of the art, called it higher cribbing. The point here is that most writers worth their salt steal other writers' moves and put them to other, often better uses. But the majority would say, again and yet again in the face of such transformative copying, no Factor 1 help and surely no fair use. Or how about music? Positively rife with copying of all kinds? Suppose some early blues artist, W.C. Handy perhaps, had copyrighted the 12-bar, 3-chord form, the essential foundation, much as Goldsmith's photo is to Warhol's silkscreen, of many blues songs. Under the majority's view, Handy could then have controlled meaning, curtailed the development of the genre, and also of a fair bit of rock and roll. Just another rendition of 12-bar blues for sale in record stores, the majority would say to Chuck Berry, Johnny B. Good, Bill Haley, Rock Around the Clock, Jimi Hendrix, Red House, or Eric Clapton, Crossroads. Or to switch genres, imagine a pioneering classical composer, Haydn, had copyrighted the 3-section sonata form. One more piece built on the same old structure. For use in concert halls, the majority might say to Mozart and Beethoven and countless others, sure, some new notes, but the backbone of your compositions is identical. And then, there's the appropriation of those notes, and accompanying words, for use in new and different ways. Stravinsky reportedly said that great composers do not imitate, but instead, steal. At any rate, he would have known. He took music from all over, from Russian folk melodies to Schoenberg, and made it inimitably his own. And then as these things go, his music became a source for others. Charlie Parker turned The Rite of Spring into something of a jazz standard. You can still hear the Stravinsky lurking, but jazz musicians make the composition a thing of a different kind. And popular music? He wouldn't be alone. Here's what songwriter Nick Cave, he of the Bad Seeds, once said about how music develops. The great beauty of contemporary music, and what gives it its edge and vitality, is its devil-may-care attitude toward appropriation. Everybody is grabbing stuff from everybody else, all the time. It's a feeding frenzy of borrowed ideas that goes toward the advancement of rock music, the great artistic experiment of our era, but not as the majority sees the matter. Are these guys making money? Are they appropriating for some different reason than to critique the thing being borrowed? Then they're sharing the objectives of the original work, and will get no benefit from Factor 1, let alone protection from the whole fair use test. Finally, back to the visual arts, for while Warhol may have been the master appropriator within that field, he had plenty of company. Indeed, he worked within an established tradition going back centuries, millennia. The representatives of 3 giants of modern art, you may know one for his use of comics, describe the tradition as follows. The use and reuse of existing imagery are part of art's lifeblood, not just in workaday practice or fledgling student efforts, but also in the revolutionary moments of art history. Consider as one example the reclining nude. Probably the first such figure in Renaissance art was Giorgione's Sleeping Venus. Note, though in keeping with the nothing comes from nothing theme, that Giorgione apparently modeled his canvas on a woodcut illustration by Francesco Colonna. Here is Giorgione's painting. But things were destined not to end there. One of Giorgione's pupils was Titian, and the former student undertook to riff on his master. The resulting Venus of Urbino is a prototypical example of Renaissance imitatio, the creation of an original work from an existing model. You can see the resemblance but also the difference. The majority would presumably describe these Renaissance canvases as just two portraits of reclining nudes painted to sell to patrons. But wouldn't that miss something indeed? Everything about how an artist engaged with a prior work to create new expression and add new value? And the reuse of past images was far from done. For here is Edouard Manet's Olympia, now considered a foundational work of artistic modernism, but referring in obvious ways to Titian's, and back a step, to Giorgione's Venus. Here again, consider the account of the Rauschenberg, Liechtenstein, and Mitchell foundations. The revolutionary shock of the painting depends on how traditional imagery remains the painting's recognizable foundation, even as that imagery is transformed and wrenched into the present. It is an especially striking example of a recurrent phenomenon of how the development of visual art works across time and place, constantly building on what came earlier. In fact, the Manet has itself spawned further transformative paintings, from Cézanne to a raft of contemporary artists across the globe. But the majority, as to these matters, is uninterested and unconcerned. Take a look at one last example, from a modern master very different from Warhol, but availing himself of the same appropriative traditions. On the left, below, is Velázquez's portrait of Pope Innocent X. On the right is Francis Bacon's study after Velázquez's portrait. To begin with, note the word after in Bacon's title. Copying is so deeply rooted in the visual arts that there is a naming convention for it, with after denoting that a painting is some kind of imitation of a known work. Bacon made frequent use of that convention. He was especially taken by Velázquez's portrait of Innocent X, referring to it in tens of paintings. In the one shown above, Bacon retained the subject, scale, and composition of the Velázquez original. Look at one, look at the other, and you know Bacon copied. But he also transformed. He invested his portrait with new expression, meaning, and message, converting Velázquez's study of magisterial power into one of mortal dread. But the majority, from all it says, would find the change immaterial. Both paintings, after all, are portraits of Pope Innocent X, used to depict Pope Innocent X for hanging in some interior space, so on the majority's reasoning, someone in the market for a papal portrait could use either one. Velázquez's portrait, although Bacon's model, is not the object of his commentary. And absent that targeting, the majority thinks the portrait's distinct messages make no difference. Recall how the majority deems irrelevant the district court's view that the Goldsmith prince is vulnerable, the Warhol prince iconic. Too small a degree of difference according to the majority. So too here, presumably, the stolid pope, the disturbed pope, it just doesn't matter. But that once again misses what a copier accomplished, the making of a wholly new piece of art from an existing one. The majority thus treats creativity as a trifling part of the fair use inquiry, in disregard of settled copyright principles, and what they reflect about the artistic process. On the majority's view, an artist had best not attempt to market even a transformative follow-on work, one that adds significant new expression, meaning, or message. That added value, unless it comes from critiquing the original, will no longer receive credit under Factor 1. And so it can never hope to outweigh Factor 4's assessment of the copyright holder's interests. The result will be what this court has often warned against: suppression of the very creativity which copyright law is designed to foster. And not just on the margins. Creative progress unfolds through use and reuse, framing and reframing. One work builds on what has gone before, and later works build on that one, and so on through time. Congress grasped the idea when it directed courts to attend to the purpose and character of artistic borrowing to what the borrower has made out of existing materials. That inquiry recognizes the value in using existing materials to fashion something new. And so too, this court from Justice Story's time to 2 terms ago has known that it is through such iterative processes that knowledge accumulates and art flourishes. But not anymore? The majority's decision is no continuation of existing copyright law. In declining to acknowledge the importance of transformative copying, the court today, and for the first time, turns its back on how creativity works. And the workings of creativity bring us back to Andy Warhol. For Warhol, as this court noted in Google, is the very embodiment of transformative copying. He is proof of concept that an artist working from a model can create important new expression. Or, said more strongly, that appropriations can help bring great art into being. Warhol is a towering figure in modern art not despite, but because of his use of source materials. His work, whether soup cans and Brillo boxes or Marilyn and Prince, turned something not his into something all his own. except that it also became all of ours, because his work today occupies a significant place, not only in our museums but in our wider artistic culture. And if the majority somehow cannot see it well, that's what evidentiary records are for. The one in this case contained undisputed testimony, and lots of it, that Warhol's print series conveyed a fundamentally different idea, in a fundamentally different artistic style, than the photo he started from. That is not the end of the fair use inquiry. The test, recall, has 4 parts, with one focusing squarely on Goldsmith's interests. But Factor 1 is supposed to measure what Warhol has done. Did his new work add something new, with a further purpose or different character? Did it alter the first with new expression, meaning, or message? It did, and it did. In failing to give Warhol credit for that transformation, the majority distorts ultimate resolution of the fair use question. Still more troubling are the consequences of today's ruling for other artists. If Warhol does not get credit for transformative copying, who will? And when artists less famous than Warhol cannot benefit from fair use, it will matter even more. Goldsmith would probably have granted Warhol a license with few conditions, and for a price well within his budget. But as our precedents show, licensors sometimes place stringent limits on follow-on uses, especially to prevent kinds of expression they disapprove. And licensors may charge fees that prevent many or most artists from gaining access to original works. Of course, that is all well and good if an artist wants merely to copy the original and market it as his own. Preventing those uses and thus incentivizing the creation of original works is what copyrights are for. But when the artist wants to make a transformative use, a different issue is presented. By now, the reason why should be obvious. Inhibiting subsequent writers and artists from improving upon prior works, as the majority does today, will frustrate the very ends sought to be attained by copyright law. It will stifle creativity of every sort. It will impede new art and music and literature. It will thwart the expression of new ideas and the attainment of new knowledge. It will make our world poorer. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.